counsel, I appreciate the respect shown in court to the public. It's difficult for us on the family court side to have public in our courtrooms in these very intensely private matters. This is the law of the land. I appreciate it.
Did you bring with you today all of your files and records pertaining to this matter?
I believe I brought most of my records, yes.
Okay. Did you receive an email from my client?
An email from your client? I have received emails from your client, yes.
All right, you received an email from my client discussing his reading part of the materials regarding the space program.
If it is, I'm sorry. If that's the case, then if he sent me something I missed that, I'm sorry.
Okay, you're not suggesting that he didn't?
No,
Okay.
my testimony is I don't recall anything that told me that he did it. But I mean, I get hundreds of emails, so.
Does the space program have an address?
Address?
Yes.
Like, where is it from? It's Yale. It's from Yale University.
If I participate in the space program,
Yes.
do I do it online or do
No. So what happened? So they're in a dissemination phase at this point in time, in which people receive training from the author and some of the people that are running this multiple studies at Yale University. And people receive the training, and once they receive the training, then they're able to deliver space as an intervention.
Okay, is there somebody in Reno that does this?
I am the only person in this whole state of Nevada.
Okay. Were you provided with a copy of the marital settlement agreement?
I'd have to go back and look at it. That would have been minimally relevant as part of my evaluation of fitness.
Were you aware that the parties agreed in writing to joint physical custody of the child in 2011?
I believe I am aware of that.
And were you aware that pursuant to an order in 2015 that the custody visitation has been a week on, week off basis for the past 8 years or so?
Yes, that is my understanding.
When you say, when you talk about the psychometric results and you indicate that the interpretation is within normal limits, what does that mean?
It basically means that there are no differences in, that would be warranted for clinical attention.
Okay, so here we're referring to as being within normal limits on all the categories that have answers on pages 9 and 10?
That is correct.
Are the opinions you have given today different than the opinions that are in Exhibit 1?
Yes, I would say that I altered the diagnosis based off of the new evidence that I reviewed, that was provided. And I think that my uncertainty associated with the presence of domestic violence, where, as I reported previously in my report, I was didn't take a stand on physical or sexual, because it was, I kind of saw it as a he said, she said, but then within the context of the other information, I altered my opinion.
Okay, but when did you notify anybody that you had changed some of your opinions?
I mean, literally the additional evidence, I just received the end of last week.
Okay, so did you notify me last week?
I did not.
Okay, or today?
I did not.
or any time between today and last week?
I did not.
Now, as I understand what's in the report, you found that the psychological profile did not suggest evidence of dysfunction related to interpersonality ability.
Yes, but given the newer evidence that I had a chance to review, I think that there is some, I didn't say that there wasn't difficulties. I described difficulties in ability to interpret the emotional needs of others.
Okay. When you met with and the child, was there a conversation about how scared son was a father on a scale of 1 to 100?
I don't recall. I know that there was a discussion. I know that we did some kind of reporting of like how much, how difficult the general take was is that the minor child was fearful of dad at the beginning based off of a lot of the anticipatory anxiety.
And was it in that meeting that you attended that as of then, he's not afraid of his dad?
I have no data to support whether or not he's not afraid of his dad or not.
You didn't ask him to state on a scale whether he was afraid?
I don't recall that, no.
It could have happened.
Objection, calls for speculation.
Are you asking a question, Mr. King?
Yes.
So, may I rephrase too, is it a possibility that that occurred, that there was a scale given? Is that what you're asking, Mr. King?
Yes.
It is a possibility, yes, Your Honor.
Then the objection is overruled with the rephrasing.
At the bottom of page 13, there is a statement that there is no indication that is a physical danger to or that he would be physically aggressive with, and it should be noted, does not believe that he would be physically aggressive or harm him in any way.
That is true.
Okay, and that's part of your summary conclusion.
That is true based off of the clarification that we did with the parent-child interaction.
When did the meeting occur? What was the date of the meeting with and you?
I believe it's going to be the last day. It's going to be May 6th.
Okay. And how many meetings did you have with?
One, plus then there was a brief conversation during the parent-child interaction. So 2 meetings with one in great detail, and then the other one was more brief, more focused on the child.
Okay. What does this 7-week program? See, if you're the only show in town, what do I do? Am I at your office 40 hours a week for 7 weeks?
Oh no.
Okay. What does the program consist of?
So basically, the space program is designed for parents only. It's one of the, and it basically utilizes the book that is acquired, and they can. I mean, it's interesting because I actually asked this question: do we have any data about what we call bibliotherapy alone with using the space technique? There is no research data. There may be a study that is kind of popping up in North Carolina, I believe, about just bibliotherapy. So no intervention, just the parents reading the book. Anecdotally, the author of Space did report that he has seen parents who are, more well-educated, more kind of involved in wanting to work with their kids, having good outcomes with just reading the book. And so that's one thing. There is another study that has just recently been published that where instead of them doing the 7 sessions, what they do is they only do 3 sessions, I believe. And basically the parents do the reading and they're able to do that. through that. So we have anecdotal evidence, just reading it might work. We also have some research studies that say kind of a more hybrid approach, reading it plus a little bit of support. It's interesting because I've actually provided both parents with some support about space, the things that are important. I also, which isn't part of the space intervention, but I think it's helpful. Since I had the minor child in my presence, I was able to kind of educate about anxiety and anxious response and those types of things. So do they need space per se? The data says that if they read it and are really involved, that would be fine. I think that if the parents choose to have me be part of the reunification effort, I think we can probably incorporate some of this into the actual therapeutic process, especially if they've read the materials.
I'm just trying to figure out how much time. How long is a session?
1 hour.
Okay, so I either do 3 sessions or 7 sessions?
That's what the data is saying, yeah.
Okay, and it's once a week?
The timing once a week you don't have to do it once a week, but basically there's some things that you could do like back to back, but there are other things that would probably be more helpful to have a couple weeks in between as part of that process.
How long is the book?
I don't know, 180 some pages maybe. It is pretty easy to read. It's not very complex. There's also some online materials, videos, examples of a variety of different types of behavior that parents can review as part of that process.
And what is the cost of the program?
The cost would be whatever the cost the therapist would be charging for the session.
Well, you're the guy, so what do you charge?
If I was charging, my typical fee is $175 an hour.
For the 3 or 7 sections?
Right. For forensically oriented types of therapeutic services.
Now, again, going back to your report, page 14, the recommendations and conclusions. You found to a reasonable degree of psychological certainty, Mr. is a capable parent who has difficulty understanding the emotional needs of, and there is no indication that he would engage in any physical aggression or harm. Is that your opinion today, or are you changing that opinion too?
I would be a little more guarded in my response. It's not my job to be a lie detector or whether or not Mr. engaged in domestic violence that was physical and sexual. I'm more convinced now that it likely happened based off of the new information. And I think that that's one of the reasons that I look at the last recommendation. At the end of the day, the court's going to tell me whether or not that there was domestic violence. If there's domestic violence, then we have to look at Mr. in a different light than the way I was looking at him when I made that recommendation.
Do you know Richard Weir?
I know of Dr. Weir.
Okay. And did you review any reports by Dr. Weir concerning?
I reviewed 2 documents that were produced by Dr. Weir. One was an evaluation, and then there was another one that was, it sounds like the court wanted an update 6 months later or something like that.
All right. Do you have those in the files that you brought today?
I can probably find them.
Would you do so, please?
It was part of one of the exhibits that I was provided, which was filed with this court on March 11, 2024. It looks to be Dr. Weir's report, but I do not have the follow-up, the 6-month here, probably because it was, from my standpoint, I wouldn't have brought it just simply because it's old information.
Okay. Is the report that you do recognize there the one that's dated October 11th, 2012?
It is.
Okay. And does it include the results of the evaluation to indicate that does not meet diagnostic criteria for a major mental disorder?
It does.
And I'm sorry, I want to understand this. You don't have the follow-up report that's dated January 4th, 2013?
No, the only reason why I have this is that this is an exhibit, and the fact that it's over 10 plus years old at this point in time. From a relevance standpoint, it wasn't something that I would have relied a lot on in decision making.
Well, you've relied upon a number of accusations that are 14 years old, have you not?
I did, but that's at the heart of the matter in this case.
Weren't you provided copies of both Dr. Weir's reports, not only by attachments to a pleading, but by my client?
He may have provided me a copy of the thing. It's not in my court folder.
Okay. And would
I
you
do recall the document and what it said.
Okay, and would you dispute that the follow-up evaluation dated January 4th, 2013, finds no additional objective information that suggests it's a credible threat to either his child or ex-wife?
That's true, but there was also some question about the legitimacy of the evaluation, and Mr. indicated that he had a previous relationship or a family relationship with Dr. Weir.
Were you provided also with a report from a therapist, Richard J. Cook?
Yes, I believe I reviewed that. That's also referenced in Dr. Weir's report.
What describe the session that you observed father and son?
Describe it.
Yes.
What transpired. Like I said, it started off with me knowing that I had a lot of information from the minor child about concerns about that was going to dominate the conversation, and so I made sure that Mr. was aware of that in order to get a good response for allowing the minor child to be able to express his thoughts and feelings, which I thought was really important given my previous conversation with the minor child. As we kind of progressed, like I said earlier, Mr. was listening to his son. At the end, he started asking some clarifying questions. I think I kind of guided him. Is there stuff that you really want to understand about this? Or if the minor child said stuff that was not descriptive, I don't know if I used the picking your nose example of that, but typically what I'm doing is encouraging the kid and adults in therapy to describe what's going on, not to jump to assumptions about what it is. And so we talk about those things. There were some places where the minor child was kind of vague, in which I would have clarified types of things. At that point in time, we did talk about his sense of being afraid, because I had previously talked to the minor child about anticipatory anxiety. That became a line of questioning for him, for Dad to see that, okay, so remember we talked about anticipatory anxiety. What happened between you and your dad in February has to do with kind of you creating a worst case scenario. How much of that is, and he was able to recognize, he actually I think used during the course of the session, I think this is anticipatory anxiety, and so we did that. After that, there was kind of the emotional kind of letting down from both parties, I think. Mr. was impacted by what his son said. He did provide some support We did some more clarification, and then there was some physical hugging, connectivity that happened as part of this process. And then we moved on to kind of talking about their life and what have they been doing and what are their interests and blah, blah, blah. The kind of a more continued rapport building.
And was that the May 6th meeting, or was that on a different date?
I believe it was the May 6th meeting.
All right. Now, you say in your report that to a reasonable degree of psychological certainty, Ms. has inadvertently contributed to the underlying resistance and fear of visitation. How so?
I believe that through this process called parent accommodation, that she saw her son in considerable amount of distress at school as a result of what happened on the fort. Basically kind of kicked off a pattern of kind of intensifying anxiety. The minor kid had anxiety before this started. That seems to be pretty clear, but this episode really kicked off even more of a sense of more physiological. So when we talk about anxiety, we kind of talk about it as kind of a cognitive thing and a physical thing. And I think before, a lot of his anxiety was much more kind of in his head. But after this event, I think he started experiencing some panicky-like symptoms, both at home and at school. And as a result, mom responded like 99% of the parents, the only ones that won't do it are the ones who are aware of this, inadvertent reinforcement. And so mom started making accommodations for him, which didn't help the anxiety. But that's unfortunately, we see that an awful lot in parents. Because, I don't want to see my kids suffer. But I'm a mean psychologist, so I would tell them to suck it up and move on. Because I just know that the more we reinforce, like not going to school or coming home early or having a trusted person at school that you can spend time with, all that's doing is reinforcing the anxiety and talking about it. And even when Miss was, and this is why the education is important. So there was an episode that happened that Miss told me about how he had a good day, but I guess he had some stress, but he made it through the day. And so that's a wonderful thing. That's what we refer to as mastery. And so he mastered that. He was successful. It may still suck tomorrow, but you know what? You made it through the day, and that's kind of the reinforcement. Well, mom's pattern of behavior has been to use his therapist as a sounding block for him if he's really under distress. So she arranged for him to have therapy that afternoon as a result of his anxiety experience, which I gave Miss, coaching and said, we just messed up a great opportunity for mastery. She didn't even think about it from that standpoint. But that's what we see in parental accommodation, is that parents don't necessarily hear it. That's why they need to hear it from professionals and understand it and kind of see it as a thing. But watching your kids suffer from anxiety is something that I think most parents don't want to see happen.
This report by the mother, when did this occur? Not the date she reported, was the date that this occurred.
I don't recall. It's in fairly close proximity. I had some contact with Miss shortly after we talked. I sent her, she ordered this Facebook while she was sitting in my office.
Is that the same date, May 6th?
Yeah, I think I don't remember. I don't remember, but very quickly thereafter, I know that she ordered it. She had a question about it. I don't even know why we talked about what had transpired, but anyway, it was guidance. It was the opportunity to provide her some guidance, and I did. I would anticipate that Mr. guidance too.
Would it be fair to say that you have had no contact with since May 6th?
That's correct.
And were you aware that the visitation is still just at the Family Peace Center?
That was what was ordered by the court. I would assume that it is continued.
And would you recommend that the visitation be elsewhere now?
Absolutely. I don't think this is not helping dad. This ain't helping the minor kid meeting at the Peace Center.
What would you recommend?
I'd recommend, like I recommended in the report, that there be some level of therapeutic visitation that will be scaled over time, providing greater opportunities as Mr. is able to respond and meet the emotional needs of his son.
So you would not recommend any kind of unsupervised visitation at the present time?
At the initial part of this, no. At this point in time, I think it needs to be in a supervised way in order for the therapist to see. I think it's also helpful for your client too, because we know that initially that this is going to happen, that it is potential the minor child is going to have some adverse reactions to increased contact with dad and dealing with some of the emotional stuff. Your client wants to have me or have that therapist to be able to have a note saying, hey, this happened and we processed it and we did things. Versus if we say, okay, we're going to give you an unsupervised visit, go out and spend 5 hours and spend some time with them, and then come back and the kid reports something. I didn't observe it. It's what the kid's saying. It's what dad says. Initially, we really want a controlled environment. There are triggers here that I don't think we're fully aware of yet. And I'm not going to learn about those triggers by him having encounters out in the community with dad at this point in time. Our goal here is to do this in a very controlled and methodical way, because I think that ultimately is going to be the thing that's going to have the less setbacks in this relationship, and that's why I want to have. That's why I may be a control freak too. That we may need to have some control in that process.
Have you been made aware that the court has already indicated that it's not going to issue a ruling that's on an interim basis with reviews? That there has to be some finality with the decision at the end of this case.
Yeah, that's my understanding.
So how would that work?
I think that, like I said, I think we'll have very good direction over the course of the next 6 months of what things are going, and then there will be other legal options if things don't go the way they need to go. I'm not a lawyer, but I've done a few of these things.
I can't remember exactly where it was provided. Wasn't there an indication in the report somewhere that the time could be more like 3 months, not 6?
I said that, I think I suggested that, I mean, the court needs to give us the guidance of what this looks like. At the point in time in which Mr. is able to meet the emotional needs of the child, there's not going to be, issues that are going to worsen his anxiety. I have no reasons to not encourage moving back to a week on, week off. I'd like to see that happen. I think it's going to be harder and harder the further we move down with this kid's anxiety and dad. Even though they've resolved some issues, there's still a lot more issues to resolve. And the longer he is away from dad is, in a theory, is the avoidance at this point in time, ordered by the court. But that's not contributing or helping him work through the anxiety that he's experiencing. The only way he's going to do that is he's got to come in contact with the thing that he has anxiety about, dad.
Is part of your recommendation for a hearing to be held in 3 months?
I believe I mentioned the idea that, because it just, unfortunately,
Well, I'm not asking why, I'm just, is that part of your recommendation?
I believe I say something to that effect, yes.
Okay. Have you testified for this attorney or her law firm on any other occasion?
I have.
Okay, how many times?
Actual testimony in this for Ms. Hardy Cooper. I don't think I've testified for you. We had a case that was getting ready to go, but then it transferred attorneys. Like 90% of the work was done, and then we transferred attorneys. Mr. Palver in the office, I haven't testified for him. We had a case that was gonna go, and then it lost steam. That was last week. So typically, we had a number of, to talk about the relationship between that office. We have a number of consultations that we've done in regards to other cases, and also therapeutic. I have been, particularly Mr. Palver, has a number of his clients have children or adolescents that are seen in our clinic.
How much are you being paid for your participation in this case?
So I charge $385 an hour for all my services. I have to go back and look, but I think it's like 35. I think I charged $3,500 for the evaluation, and plus my time today, plus some meetings beforehand with Ms. Hardy Cooper. So I think that's another $3,500-ish. So at this point in time, I think it's like two $3,500s.
You also summarized and concluded that not meet the diagnostic criteria for personality disorder.
Yes, but as I said during my testimony, I think based off of the new evidence that I received, I would alter that opinion.
Okay, the opinion that you didn't notify me about.
That's correct.
Did you confer with Jerry Potter about this case?
I did not.
I have no further questions.
Read your back.
One more. So Dr. Cord, you just testified that you would love to see a situation where they could return to week on, week off, right?
Yes,
You're not actually making a recommendation that they return to week on, week off at this point, are you?
I am not.
Okay. In that joint session that you had with Mr. and, did Mr. report that he had quit substances cold turkey?
He did.
Was initially, and when you initially had that session was, with your interview with, was he initially protective of telling you things about his father?
He was very reluctant, very guarded in talking about what would happen.
Okay. What's the estimated cost of reunification and therapeutic visitation based on your experience here?
Probably about $3,500.
Did Miss, when you gave her that correction regarding the parental accommodation that you talked about and then the subsequent session with Ms. Stoddard, was she receptive?
She was.
You said something earlier that when Mr. King asked you about whether there was, whether Mr. physical threats, to recall him asking you about that?
I do.
Okay. You gave a statement, and you essentially said that if the court finds that there was domestic violence, then we have to look at this differently. So let's assume that the court does find that there was domestic violence in this case. How Does that opinion change about whether he's a physical threat to?
Potentially, future, best way to predict future acts of domestic violence directed towards, a spouse, partner, or children is the past behavior.
How familiar are you with domestic violence in Barry?
I'm very familiar. At one point in time, I was actually on the board as the vice president of Safe Embrace. I've treated a number of victims of domestic violence over the course of my career. Some of the worst horrific ones that you could ever imagine, and have had a lot of dealings with domestic violence. I also do a lot of it in my criminal practice, where domestic violence has been alleged, so a lot of times for prosecution, where they're trying to substantiate a pattern or cycle and why somebody goes back, counterintuitive types of behaviors that happen in domestic violence cases, particularly sexually related cases, like why do they go back, types of questions.
So then is it fair to say that based on your evaluation here, you do not believe that there has been a physical harm?
Yes, that was not reported by him, and I don't believe that that's happened.
Okay, but and you believe that there was domestic violence in this case under the totality of the circumstances?
I do.
Both physical, sexual, manipulation and control, emotional?
Yes.
Okay, and so considering that, do you believe Mr. presents a physical danger to?
Until those issues can be explored as part of a therapeutic process, I can't say that he's not.
No further questions?
Is the witness excused?
Yes, Your Honor.
Could I ask a couple more questions?
What would be the basis of opening for recross? Would you like to make an offer of proof, Mr. King?
Yes, the offer of proof was, I now want to ask him the date and type of physical violence that he's concluding has happened.
Ms. Hardy Cooper, as to the request for recross,
Ask that one question, you can ask it. Don't object.
given no objection, go ahead, Mr. King.
Can you give me the date and specific violence, physical violence, that you believe that my client perpetrated upon his ex-wife?
The specific date is not available. It occurred during the course of the marriage. There was a description that Ms. indicated he had held her down on multiple occasions and engaged in forced intercourse. She also reported about this letter that she was forced to write in regards to the affair in which a gun was placed upon her. I believe, that those are likely incidents that have occurred that are sexual in nature and also physical in nature. There's also evidence that while she was pregnant, that he engaged in pushing her down during her pregnancy with the child, with a minor child now. So I think that those are at least a couple examples. They occurred during the marriage. I don't see anything or report anything that happened post divorce or separation that occurred. I don't find any evidence based off of my conversation with Ms. Perkins of physical or sexual abuse, and I specifically asked her those questions.
You were never provided with a letter.
Objection, it's outside the scope of.
Which is outside the scope of recross. Recross is very narrow, as you know, Mr. King, so if you have an offer of proof, give it to me.
He gave an incredibly long narrative in which he referred to the letter, and I'm still trying to follow up on how we can conclude that an act of physical violence occurred just because it was reported to her.
That's a very different question than the letter. This recross is not a second bite at the apple. Recross is something that you didn't see coming, that came up on redirect as to why I should allow recross. I believe that he also indicated that he believed that domestic violence occurred in his direct testimony. So as to the recross, given the narrow scope, I'll allow why he believes, or what he's making the finding, that there's a likelihood of physical or sexual domestic violence. I'll allow that question, but getting into the forest for the trees could have happened and should have happened on regular crops. So as to that one last question, what specifically is it that you're basing your conclusion that you believe it's likely that Mr. engaged in physical and or sexual violence against Ms.
I think the totality of the evidence, Your Honor, supports the idea that something sexually has happened. The new information that I received just further reinforced a belief that these things were happening.
So if I can stop you there, I think that's the same issue that Mr. King is having, which is it's a very vague and general conclusory statement. I believe that what Mr. King is asking is what specific, I've heard this allegation of new evidence numerous times now, but I've not heard anything about what the new evidence is. So if I'm hearing you correctly, you believe, based on statements Ms. made, was there anything else other than Ms. testimony that leads you to believe of the physical and sexual domestic violence being more likely?
Your Honor, sorry, he's referred to the new evidence several times. Can you ask him what that is so that he can?
And I absolutely will. But as to you had two sections in there. So me now asking questions on the court, I'm not making recross for Mr. King, but I have similar questions that Mr. King noted. You were asked about what the evidence is, and you said it's the totality of the evidence. So can you break that down for me, and what specifically leads you to make that conclusion?
Can I look at the exhibit book to let you know what the evidence is really?
And if you do look at a specific exhibit, if you would just let all of us know so that if it isn't evidence, I can look at it, but so that council can look at everything.
Your Honor, I don't think I need to look at the exhibit. I just want to tell you what exhibits I placed weight on.
Okay.
And so I would tell you that I placed weight on Exhibit 2, Exhibit 3, Exhibit 4, Exhibit 5, Exhibit 6. Exhibit 25, Exhibit 26, which I had previously done, but in this exhibit book.
Anything else?
No, Your Honor.
And then then the second part is, when you reference new evidence that you received that changed your opinion, can you just tell me what specifically was the new evidence?
I think I just did, Your Honor, except for those last two exhibits, 25 and 26, I had previously seen. With this old historical stuff, the 2010s, 2012 stuff, I didn't have access. It came up in a discussion with Miss Hardy Cooper about that. Is there a pattern going on here? So I saw a loose pattern in the data that I had previously seen, and then looked at his conversations with the minor child and kind of said, "Oh, that's interesting. It has a similar dynamic." That's when she says, "Well, can you look at these things and what do you, the things that the numbers except for 25 and 26," and it just provided more evidence that this is a pattern that I was seeing related to the credibility, the putting greater credibility in Mr. Statements versus Mr. absolute vehemently denying these issues.
Okay, so the new evidence specifically was exhibits 2, 3, 4, 5, and 6.
Yes, Your Honor.
Okay, because the court asked questions within the very narrow frame of my questions, I have to allow both Ms. Hardy Cooper and Mr. King the opportunity, based on the scope of my questions only, if they have any further questions. I turn to Mr. King first, because Ms. Hardy Cooper would always have the last right because you're her witness, so please bear with me. Mr. King, based upon the scope of the court's questions, which were not yours or rephrased yours, Any further questions based on the scope of my questions?
No.
Ms. Hardy Cooper?
No, Your Honor.
All right, the witness is excused and relieved of the subpoena, if he was here under subpoena, is that correct?
I don't recall if I subpoenaed him, Your Honor, but he's released.
All right, Dr. Court, thank you for being here, you're excused.
Thank you, Your Honor.
All right, counsel, it's 4:59 by my clock. Reconvening at 9 tomorrow, or do we need, Mr. King, are you feeling pressed for time still? Do we need to start earlier? You had some concerns that you might be.
Well, I've only need one witness, so I think it's finished.
So 9 o'clock still works for everybody, lunch between noon and 1:30. Anything else other than your witness? Do we know what time your witness is gonna be here tomorrow?
So she is going to be testifying remotely because she's traveling out of the state.
Okay,
So,
will she be ready right at 9?
I think she can be ready right at 9.
Okay, I just wanna make sure that we don't all show up at 9 and then find out that the witness
Sure.
isn't gonna be available until 10.
I will confirm this evening, and then if it's okay, I'll send an email to the three of us together to confirm that time.
I'll be here at 9.
Okay.
Mr. King, anything else?
Well, I'm kind of confused. We had to make a special accommodation for her for Thursday morning, and now I'm hearing for the first time that she's not even going to appear in person. So it sounds like something's changed.
I've always disclosed to the court that this is a witness that was out of town and was going to be testifying. She was, as I disclosed today, I said that she wasn't available today because she was on a flight out of town and wouldn't be arriving there until approximately 2 p.m.
So she was traveling today,
Correct.
then that's the reason for the accommodation. Anything else, Mr. King?
I must have misheard. I just wanted to send it writing here. All right.
And I frankly don't remember and don't have it in my notes as to why the accommodation, I just have that it was Thursday morning.
She was not available. She's a school district employee, it's summer. That says a lot of it.
Anything else for today's purposes,
So,
counsel?
Your Honor, in preparation for tomorrow, will we be doing our closings immediately after that witness? Or do you intend for us to come back after lunch to do that, our closings?
I'm happy to do it whatever counsel needs. I usually leave it to the two of you to say if you need a few minutes to kind of gather your thoughts before making a closing argument, or if you want to go directly into closing argument. If somebody asks me for a few minutes, I'm gonna give them a few minutes. I've generally not given people several hours. Do you have your thoughts right now, Mr. King, as to whether or not you're gonna want a slight break or whether or not you're gonna wanna move directly into closing?
Would want to move directly. We only have one short witness. I don't think it's going to have much bearing on the arguments changing in any way.
So if Mr. King's comfortable moving directly into it, I would either do that or do short breaks, generally of no more than 15 minutes.
Yeah, I would say a short break of 15 minutes would be fine.
Then I'm not gonna afford longer, but I'm gonna treat this case just the same as I would anybody else. If somebody wanted a few minutes to gather their thoughts, I would give it to you just like a morning recess. But generally, I don't take morning recesses for more than 15 minutes, so I wouldn't give more than that, but that's what we'll plan on. Ms. Brown will create the Zoom link and have that ready for tomorrow. She will email that to both counsel, just so that there's no ex parte communication, so that you have it for your witnesses, if that link hasn't already been provided. Mr. King, are we going to have any argument tomorrow with regard to rebuttal and or recall, or do you know at this point?
I don't know at this point, but we're going to physically appear tomorrow, are we not?
Oh yeah, we're all here.
Okay.
I'm here, you're here, just
Alright.
one witness who might be by Zoom. Okay, then I'll take whatever argument there is, but it sounds like for the agenda, it's gonna be the witness. Then if there is arguments on recall or rebuttal, everybody knows that to be ready with actual legal citation for me, so I can make a cogent argument and then a ruling on the same. And then closing arguments with no more than a 15-minute break between the close of evidence and closing arguments. Anything else for housekeeping matters before we adjourn this evening? Okay. Council, go ahead. Anybody who wants to leave their stuff behind, go ahead. The courtroom will be locked and we'll unlock it a few minutes before we reconvene tomorrow. Have a nice evening. See yourselves out. Please don't stand for me. I have to clean up.
Honorable Dixie Grossman presiding.
Thank you. Please be seated. All right. Do we have our witness ready to go?
Yes, she's coming.
Council, do you have any housekeeping matters while we're getting this loaded?
Your Honor.
page, my eyes are all over, can you read what that says in there?
No. That's my notes.
Rachel, what would be the last name?
Foster.
Foster, okay. It looks like we have a Rachel Foster in the waiting room, and my camera here doesn't pick that screen up, sorry. Is that who you intended to call?
Yes, sir.
All right. Ms. Foster, any objection, Mr. King?
No.
Okay. Ms. Foster coming in now. Hello, ma'am. Are you able to see and hear? You'll probably need to unmute your device. There you go.
Yes, I can see and hear you.
Perfect. I'm gonna do my best to move some screen locks here in the courtroom. But as you're probably aware, the JAVS system in the courtroom is voice activated. So every time somebody talks, the cameras in the courtroom are gonna bounce around. The camera should stay on whatever attorney is asking you questions. If it doesn't, I'll do my best to control all of the controls manually. But if it starts to jump around a lot, I apologize now. There's usually very little when the computer starts to do that I can do about it. If it interferes with your ability to answer the question or hear what's going on in the courtroom, please interrupt and let me know, okay?
Okay,
And is it Rachel Foster spelled the same way that it is on the screen?
that's correct.
Ms. Foster, would you be so kind as to please raise your right hand to be sworn as a witness?
Do you solemnly affirm the evidence and testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Ms. Hardy, go ahead and lower your hand, ma'am. Thank you, Ms. Foster. And can you confirm for me, Ms. Foster, is there anyone else at your location who can overhear or oversee any portion of your testimony or the court hearing today?
No, I am by myself.
Okay. Do you have any exhibits or documents in front of you?
No, I do not.
Please make sure that you're not looking at any devices, that you're not on any cell phone or computer where you might be able to get information. Please do not look at any documents unless or until you're told specifically by counsel. And then if you are asked to look at something, I may ask you to move your camera just so you can show me what you're looking at, please. Any questions about any of those instructions, ma'am?
No.
All right, Ms. Hardy Cooper, when you're ready.
Thank you. Please state your name for the record.
Rachel Foster.
And Ms. Foster, have you been subpoenaed to testify today?
Yes, I have.
Okay. Where do you work?
I'm a school counselor at Swope Middle School.
Okay. And are you familiar with?
I am familiar with he is on my caseload. I have letters G through N, my last name.
And then how did you come to have a familiarity with
Yeah. So like I said, I'm a counselor through last names G through N. Has been on my caseload the last 2 years. He was with me as a 6th grader as well. I will say I did not know him as much last year as I did this year. He's a good kid. He's in our leadership school or our leadership class. So that is how I know of him. This year he came more on my radar about mid-February-ish, maybe a little bit earlier, due to some personal reasons. Kids get referred to me through teachers, parents, self, maybe seeing them in a hallway or something. We received a TPO from the courts in February. I have unfortunately received those for various students on my caseloads throughout my years, which indicates that something has gone on. So we just keep an extra eye on students in those situations, and so that was what occurred. And then he began coming to me in about mid-February, because he was not able to get through class. His brain was distracted by outside things going on. He never elaborated much on what was going on, but you could just physically tell he was pale, he was tired, things like that. And so we would
As part of the your work at the school, were you made aware that there was a temporary custody order related to?
Yes, we get the court documents. They go to our registrar so that they can be filed in a student's file through the computer, and we're made aware that there's a TPO or whatever it may be, a custody. He can only go to this person, or she or he only talk to this person, so that we can follow what is ordered by the courts.
Okay, so you mentioned that you started noticing that in early February. Can you give either an exact or an estimate as to how often that happened?
Yeah, so I would say attendance started getting affected mid-February. About whether
Objection,
he would miss a
non-responsive.
class.
One moment. I'm sorry, Ms. Foster. I know there's a little bit of a lag time on Zoom. If you would be so kind as to stop speaking, even if you're in the middle of a word, if you happen to hear the word objection, I'll deal with the objection in the courtroom. And then if appropriate, I'll come back to you to pick up where we left off, or I'll give you other instructions. Please bear with me. The objection was non-responsive.
Yes.
Ms. Hardy-Cooper?
I was asking her to describe what the interactions were after February.
That was not the question. The question is, how many times did she see it?
Maybe I'll just rephrase it to make it easier.
Okay. And I thought it was more to the latter, but I appreciate the objection. And so I appreciate the rephrasing. I think with the rephrasing that will take care of the objection. Ms. Foster, there's going to be a different question. Please do not answer the prior question. The portion is stricken at Mr. King's request. Ms. Hardy-Cooper, go ahead.
How many times have you observed, to the best of your knowledge, inability to complete his schoolwork?
In my office 4 to 5 times.
Okay. And then are you aware with the absences that he had after early February?
I am aware of those absences. I can't speak for the exact number, but there were about, I would say, 8 to 9.
And in the 4 to 5 times that you met with how did he appear?
Come to my office very distraught, pale, not able to function, and he would communicate that. He wouldn't communicate the exact reason causing him to feel that way, but he would say, I'm tired, I can't focus, I just need to take a nap, I want to go home. I would really try to work with him through that, reflecting what can you control, what's going on, how can we stay at school, you have math, I'd really like to get you through that. Can you work down here? Do you want to take a little break and then see how you feel? There were a handful of times that I did have to call Miss to see how we could proceed, and we would work together to try to keep him at school to do his work, at least his core work, to get through some of that. But there were a few times that he did end up going home because he just could not feel like he could regroup to focus in class.
In your contact with Ms., did she ever tell you about her personal history with Mr.?
No, she did not. We just spoke about
Did she talk to you about the circumstances leading up to an incident in February with you this year?
No, she never gave me exact information. She just said that it has been affected by things that have gone on in their personal lives as a family.
And but you were aware that there was a temporary custody order limiting Mr. contact.
Ask him that.
Oh, go ahead. I believe she said yes.
Ms. School Board Trustee, are you aware of that?
Yes, I am.
And you're aware that she is the president of the school board?
Yes, I am.
Has that had any impact on your dealings with her related to? Does it have any effect on your testimony here today?
No, it does not.
Do you have any personal relationship with,
No, I do not. I've only spoke with Miss over the phone because of school.
Okay, thank you. No further questions.
9:10, Mr. King, cross-examination, sir.
Yes, Your Honor. Are you in Nevada today?
No, I am not. I am in Chicago on a personal trip for summer.
Okay. You indicated that you received the TPO. Did you also receive a copy of the application for the TPO?
I did not. I just received a TPO. The school received a TPO stating that he did not have contact with his father.
And I assume you reviewed that document.
Yes, I did review that document. It was very basic, just stating, I think it was 1.5 pages, that he did not have contact.
I think you testified that you saw 4 to 5 times. Can you tell me the dates of those 4 to 5 times?
Can I look at a piece of paper for those dates?
What would you be looking at?
The attendance records?
Yeah, I'm not talking about attendance right now. I'm just talking about the dates that you met with him. Would this record indicate those?
Yeah, it's documented through attendance. It will say EMI, which is excused misinstruction, and I change those in the computer when a student is in my office working with me and missing class.
All right. Yeah, if you can tell me what those 4 to 5 dates are, I'd appreciate it.
I had office February 9th, March 13th, and June 6th. And he worked in the office on February 20th as well.
Would that February 20th entry be different from the other 3?
Yes, because he worked in the office, not with me. I was unavailable to work in my office, so he worked in the main office.
I believe you also testified that he missed about 8 to 9 days of school. Can you identify those dates?
Yes, so those are coded either as EMD, which is excused medical note, or medical, which is MED. So on May 30th, he was excused through EMD. On May 17th, he was excused for EMD. On May 9th, he was excused for EMD. On April 30th, he was excused medical. On April 15th, he was excused medical. March 11th and 12th, he was excused END. February 29th, he was excused END. And then February 6th, 7th, and 8th, he was excused medical.
I'm sorry, what 3 days? February 7th, 8th, 9th?
6th, 7th, 8th.
Thank you. How many times have you met with the mother of, during the period between February 1st and today?
I have not met Miss in person. I have only talked to her on the phone twice when she wanted to be picked up.
Okay. What are those dates?
Those dates would be when he left, so February 9th and March 13th.
Have you reached out or had any contact with,
I have not.
how long have you been the school counselor?
I just completed my 7th year.
All at Swope?
No, I've been at a couple different schools, unfortunately, with the overage process.
All here in the Washoe County School District?
Correct.
I have no further questions.
Redirect Ms. Hardy Cooper.
Ms. Foster, did talk to you about any visit with his father?
Beyond the scope?
He was asking about the visits and when she talked to him, what was happening with the mistake.
I believe it is beyond the scope. He asked about specific dates as to when the child left and whether she had any contact with the father. The objection is sustained.
No further questions.
The witness is excused? I assume?
Yes, sorry.
Oh, that's okay. Ms. Foster, thank you very much for your time. You do not need to wait by the computer. You are freely excused and relieved of any obligations under your subpoena, ma'am. Thank you again for your time. You're welcome to log off completely.
Okay, thank you very much.
Thank you. Ms. Hardy Cooper, any further witnesses, or does that close your case in chief?
This closes our case in chief, Your Honor.
And Mr. King, I understood that you had no other witnesses, so your case in chief would also be closed at this time. Is that correct, or am I missing something?
We identified the only witness. We then entered into an agreement which allowed me to explore direct and cross.
Yep.
So, yeah, that is our case. We would rest.
Okay. So both sides having closed their case in chief, is there any further request at this time? Okay. Then, counsel, I believe that we would move into closing arguments, but you both know me that once we close evidence, I just like to make sure that everybody's on the same page before we close, in case anybody thought that there was something in evidence. Let's do that now before we formally close, because I don't want to have to go through a process of reopen. I don't think it changed much from yesterday, but here's what I have. And Ms. Brown will interrupt and correct me if I have anything wrong. I'm going to go through all of the exhibits first, and then we'll double back to all of the judicial notices taken. Exhibits that came into evidence: 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19. 21 was offered but not admitted. 23, but only pages 1 and 2 offered for the purpose of the private and confidential document. The actual article materials itself were removed, except for the headline, where it was published, and the date, as well as the notation on page 2 as to the confidential document. Everything else of Exhibit 23 was not admitted.
Your Honor, I'm sorry, I don't mean to interrupt, but
Go
can I
ahead.
go back a second?
Yes,
Do I understand that 20, 21, and 22 are not in?
I have 21 offered but not admitted. I have 22 was never offered.
Okay.
Do you have something different?
That's accurate.
Okay.
And then on 20?
3?
No, 20.
Oh, on 20?
Not offered.
I have not offered. I'm only going through the stuff that was offered in the rulings.
All right.
So that's 21 was offered but not admitted. Then I jumped down to 23. We went through that. 25 offered, admitted over objection. 26, same. 27 was admitted with a redaction. Council marked the 2 redactions. 28 admitted. Nothing else came into evidence or was otherwise marked or offered. Moving on now to judicial notice. Court took during day 1 judicial notice of TPO 1-2. Judicial notice taken of all orders in this case. Judicial notice taken of all Peace Center reports. Judicial notice taken of Jav's recording of the hearing. I confirmed yesterday that the hearing date was in fact August 10th, 2024. The judicial notice was taken for the
You
purpose.
said August, Judge.
It was April
Oh, I'm
10th.
sorry, did I say August?
Yes,
Thank
ma'am.
you for the correction, Mr. King. April 10th, 2024. Judicial notice taken for the limited purpose of the discussion and any orders made with regard to the Family Peace Center reports and Family Peace Center visits. Judicial notice taken of the motion as to the date and time filed for a motion to remove first right of refusal. Judicial notice taken further of the registry of action with regard to confirmation of no opposition and the resulting order. That's everything I have, counsel. Anything that anyone believes was omitted, does your record
This
match?
judicial notice taken of FB 12, is that the TPO? Okay, because I may have confused matters on the TPO.
I have no judicial notice taken of any FV 12 case. I think it was TPO and.
No, and
No,
back then I
it
think it was
wasn't-
still FD,
it
and so
wasn't
they hadn't
FD.
switched over to TPO.
Oh, was it FV?
Yeah.
Okay. So do you have FV 12?
Yes.
And you originally had in the record that it was a TPO 24. Everyone acknowledged that that one was stricken. Okay. Correction to TPO 12 should be FV 12. Thank you, Madam Clerk. Anybody else have any other changes before we close evidence? Okay. Evidence is now formally closed. Counsel, I indicated that I would grant no more than 15 minutes if you wanted it. If you don't, that's fine. We'll move directly into close. How do you wish to proceed? I think Mr. King was ready to proceed regardless. Ms.
I'd like
Are you
15 minutes, please.
15 minutes?
Yeah.
Okay, then we'll take a 15-minute recess and we'll come back at 9:38, pardon me, 9:38, and we'll go on the record then with regard to closing arguments. Okay, thank you.
All rise.
Denies the sexual and physical abuse. He didn't deny the emotional abuse. He had no remorse. He expressed no remorse and offered no testimony about how he behaved in those text messages with Miss when they were married, while she's pregnant, after she's had the child, shortly after the divorce. There's horrible names on a regular basis in there. You're a whore. You're a bitch. You bringing up her going outside the marriage, saying she's a worthless piece of shit, on and on and on and on. And he still believes that to this day, as far as we can tell, because he didn't deny that he feels that way now. In fact, we heard testimony that he has continued to hate her through his relationship with Ms. Perkins that he wanted her dead, and that Ms. Perkins had heard him say that he wanted her dead during that time. Ms. didn't know he was feeling that way at the time because things were relatively calm while he was in that relationship with Ms. Perkins, which I'll remind you was from 2012 to 2019. It's interesting that Mr. continuing to hold on to these feelings about, encounters that she had 15 years ago, especially in light of the fact that he too had gone outside his marriage, but didn't express any remorse or any insight that maybe that is an unfair thing or inappropriate thing to still feel this way and take actions upon it against Ms. We have changed circumstances after the divorce from Ms. Perkins reignited the pattern of domestic violence from Mr. Ms. Again, you see examples from 2019 to the present that show manipulation, intimidation, and control. He spoke about his father's explosive temper on February 4th, that he, through Dr. Cord, believed that his father would hurt him, physically hurt him, that he threatened to run away if he was forced to return to his death. Now, we understand that, unable or unwilling to give testimony about the facts of February 4th. I think everyone in the room can notice the change in demeanor that happened when you went from discussing neutral topics to topics that are pertinent to his relationship with his parents and what happened on that day. I thought it was also very interesting that when I, on cross-examination yesterday, I cross-examined him about what he had said about February 4th in his declaration. And that he said the voicemail language and actions was, I think it was regrettable, inappropriate. He acknowledged some of it inappropriate. When I asked him, did he mean that he felt that way about his interaction with Jerry? He said no. He said it was the voicemail that he had left for Jerry. And in fact, you didn't hear any testimony that Mr. felt bad about his behaviors on February 4th, the incident that scared so much that he sought help from his mother to be able to have a change in custody and continue to suffer after that, missing school, having the anxiety that you heard about from Dr. Cord. One thing that was incredibly important to was that his father had told him in that joint session with Dr. Cord that he had quit everything cold turkey. And, I think that's an insight into believing that his dad is a threat and is dangerous when his father is impaired. While my client doesn't necessarily agree with that, there has been evidence that you heard that there was an association with heightened anger, quick to temper and explosiveness, and lack of control related to him being intoxicated. For example, the message to Ms. Goddard was left. He acknowledged to Dr. Cord that he was impaired. He told us he wasn't, but that wasn't consistent with what he told him. He also told us here that he hadn't had a drink since the end of January, when it's conveniently located just prior to the February 4th incident, but he acknowledged to Dr. Cord that he was impaired that day as well. When we look at the NRS 125C0035, which is our best interest analysis, we believe that we presented a clear and convincing evidence of domestic violence that occurred during the marriage and then continuing with a pattern of manipulation, control, and intimidation to this day. Some examples of that include excuse me, in 2012, there was evidence presented that Ms. filed her motion to ask for the right of first refusal to be removed, related to her belief that Mr. to find out information about her health situation at the time, and using a way to control that and get information about that. He denied, he didn't agree to that, thereby forcing her to expend money and file a motion. He didn't bother to respond to that motion, but instead he took other action, which you heard, the voicemails, the angry, explosive voice. I would say that it was clear that he was quite angry, and it did sound like the demon voice that other folks had described. he also reacted by, he denied this on the stand. The timing just couldn't be better, is that in the time when he should have been responding to opposition, he sent to that family was a message talking about how she was rubbing her affluent lifestyle in his face, that that he wasn't going to be paying for anything extra anymore, and that he was glad God gave her cancer. So, and went on the stand. Now that to me, the timing is more likely than not in response to the right of first refusal, which he went off on Ms. Goddard. But he instead says the reason why he did that is because he had recently had a car, and he saw her drive by, and that Miss look and kind of went like this. So I don't know how a look like that when driving by with a car, noticing that maybe she has a newer vehicle, justifies a perception of belittling, flaunting the affluent lifestyle, telling her that he's glad God gave her cancer. It's an example of his explosive temper and his inability, his like hairpin trigger on what's going to happen in response to very minor things. That's uncontroverted, whether you believe that it is in response to the right of first refusal or to what he said out there. I think any rational person can see that that is a wildly disproportionate response to what was happening. You also heard about, excuse me, you heard about how Mr. would have negative reactions to very neutral things. He even acknowledged it on the stand. For example, Ms. Perkins testified that when he received a Father's Day present that Ms. had purchased for to his father, he took that as she was trying to get back together with him, and that she was, constantly like getting on him. Same thing with a Father's Day card, which those two things would be nice gestures that a normal co-parenting relationship would be supportive of. She testified that even seeing Ms. soccer game or receiving a neutral family wizard message would trigger a response with Mr. She even testified that sometimes that response was so big that he would drink a handle of Captain Morgan's in a day and a half, and sometimes she took him out of the house so that he wouldn't be around his father when it was that way. Mr. did not deny that he currently and still hates Ms. I thought it was very interesting that he did not deny. We have said throughout this entire case that one of the big issues in showing the manipulation and power and control is that he has held that letter over her head for 15 years and referenced it at times. We said in our initial pleadings, we said throughout this entire case, that he told her that he was going to hold that letter and that he was going to release that letter so that right before he killed her, so that everyone would know what a horrible person she was before she died. He didn't say anything about that. He didn't deny it. He didn't have any excuses for his poor behavior on the family wizard messages. He didn't. He acknowledged that he was agitated by any response from her to adjust for vacations or visits from family, and that recognizing that was a question, that was an issue for him, even though it would be potentially in best interest to have those things. We recognize that she didn't go to the police, but she testified regarding that, but she was fearful that he would kill her if she did. I think that's considering the testimony that you've received, that is a reasonable fear of hers. Mr. I think also that, it was so long ago, it doesn't matter what happened back then, because here we are now. But it's just not true. Your Honor, as you know, Castle v. Simmons says that you are to view the totality of domestic violence if it's still continuing today, and I think we presented ample evidence that that's continuing to happen now, not physically, but in the manipulation, intimidation, and control. A lot of times in these cases, domestic violence cases, it comes down to credibility issues. There's a lot of he said, she said in a case. I want to remind you that he has serious credibility problems and was inconsistent in his testimony and impeached with text messages that had been gone over time and time again, and that he had plenty of time to review and know what was coming, what was going to be potentially asked of him at this hearing. He testified that he had never burned anything of theirs. And then on cross, I showed him in a text message that he had actually said he was burning stuff in the fire pit. And at the point, he admitted that he had been lying at that point. So there's one time we note that he was willing to lie. He denied forcing her or asking her to sleep in a Walmart parking lot, yet his text messages showed on cross that he did tell her to sleep there and actually encouraged her to stay another night so that he could watch her while he was working. He acknowledged that his firehouse was across the street from a Walmart. In his declaration, he claimed, it's filed April 17th, he claimed that to call the police. Yet, as we know in this case, she never called the police on him. And so that was untrue testimony as well, at least through the form of a declaration. In his testimony, he denied that the school police was called on him at elementary school. Yet, again, in that same declaration made under oath, he acknowledged that they had called the police on him. So again, inconsistencies. I already talked about the inconsistency on when he said his last drink was. I won't say that again. But he claimed, and it was important that he was sober and he's testing. Yet he provided no such proof of that. When he's lying and inconsistent about all of these other things, I don't think that he has the credibility to be able to testify and that you should believe in, for him vouching for himself that he has been testing clean. That is an exhibit that could have been very easily offered and provided in this case. He also lied about completing Dr. Cord's questionnaires fully. He said that he filled it out and didn't realize that there was a question, but this was a form that was sent to him to complete on his own at home, and he opted to pass on certain questions. And while that may have been okay for the ones that sounded like they're related to a current relationship, it wouldn't be okay for the rest of them. Mr. Hall referred to Ms. as a bitch in his interview with Dr. Cord and showed that he was still very focused on retribution and punishment for what she did 15 years ago. We still think it's a very serious thing that the sealed document, oh, sorry. Okay, moving on. He's uncooperative and agitated. I think the presumption goes into effect that he should not have joint physical custody and that primary custody should be granted to her. The best interest factors that are applicable are the conflict, ability to cooperate, mental health of parents, needs of this child, and the domestic violence presumption. Is that 1 minute, Donna? I tried to fast talk last.
You're at 7 seconds, so I appreciate
Okay,
that,
thanks.
with the 5 minutes reserved,
Yeah.
so 5 minutes still to this side.
Okay.
Mr. King, your entire 20 will start, one moment, let me just reset the timer. Do you want any warning when you get close to the end, or do you just want the timer to go off, Mr. King?
Perhaps if you did give me a 3 or 4 minute warning somewhere in there.
Okay. I'll,
Yeah, perhaps I should ask for that too.
not a problem. I'm happy to give you a warning at 3 minutes and 4 minutes. I'll just wave this. That might be a little bit more than just my finger standing up there. So, okay. Mr. King, your 20 minutes starts now.
Thank you, Your Honor. I apologize to the court that I didn't ask for permission to sit throughout my examination of witnesses. Ever since we've had these microphones, it's always been preferable, so that's why I'm still sitting here now.
Thank you.
I'm going to be 18 in just over 4 years, in September of 2028. So there's only 4 years left of his childhood, and that's a really important fact in this case. My client has had joint physical custody since 2011, since he was essentially 1 year old. So we're talking about a period of about 12 years. I don't know if I'll have enough time to talk about it, but I'd like to talk about the child's testimony at length because a lot of the things that he says directly refutes the need to modify custody. I also want to ask you, I'm anticipating you're not going to decide the case today, that you're going to take it under submission. And I'm going to ask you to consider today revisiting the interim visitation between now and when your order does come out. While counsel points out all of the bad things that are in the communications between the parents, she attempts to minimize by describing it as a fine, no big deal. Adultery is despicable. It destroys people's lives. On that subject, I could go on for 2 hours, but I don't have 2 hours to talk. But the content of these text messages, sure, it's unacceptable, but it is in 2010, 2011. It's over 12 years old. And while these exhibits all came in evidence because he admitted that he sent them, I don't think that that's necessarily a basis to change custody. In fact, we could say that there's been no substantial change of circumstances. Things aren't any worse now. Arguably, they might even be better. Anyway, we'll go through the factors here in a minute, but I would suggest that there has been no substantial change of circumstances, that it's not in the child's best interest to continue to restrict and deny visitation with the father, and that the mother has failed to meet her burden. Now, after the child's testimony, we heard the testimony of the mother, and I would argue that she lacks credibility in some areas. The court saw herself the performance, the acting that was so different in the closed session when the camera wasn't on, when the press wasn't attending, to the testimony when the press was in and the camera was rolling. I believe that the thing was done specifically to do that, and I believe her credibility on a number of these things was no more than an appeal to sympathy, passion, and prejudice. She referred to the letter, she referred to guns, she referred to the C word and the F word, and her volume extremely higher. Her tone of voice extremely different than in the two sessions. I'm not saying that everything she said is not credible, but what she said during the closed session, I believe, was not credible. I believe the report of Dr. Cord was the only evidence that we came to court knowing about. He, by himself, admitted that he didn't give anybody, or didn't give at least the father's side any notice that he was changing opinions on the very report that we were looking at. I would suggest that this is an example of ambush. But what it really came down to was, what did he recommend? He recommended this space program. And how about that? He's the only show in town. In fact, he's the only show in Nevada. So it was kind of weird to hear somebody give opinions and then try to solicit additional business. And there's nobody else in Nevada that can do the space program. I believe the court will have noticed that during his testimony, he was actually signaling, mouthing, and being signaled back by both counsel and by the mother during his testimony. He didn't bring all his files. When asked a question, he'd say something like, oh yeah, father never got back to me about the space program. Then I'd ask him, did he send you an email? Oh, yeah, I didn't bring it with me, or whatever it was he said. Let's go back to some of those recommendations, though. He says that there's no indication that my client's a danger, that he would be physically aggressive with. He said things that, again, I already said they were contradicted by the child himself. It seems to suggest that, well, it says specifically that to degree of psychological certainty, Mr. is a capable parent. Yet then, he tries to undo all his opinions in this surprise sneak attack. I would suggest that you should strike all of his testimony regarding his changed opinions. He describes as new evidence, and he gave an example of new evidence, some of these text messages that are 12, 14 years old. The child said that he did not say he was going to run away. He did not say that he thought that his father was going to hurt him. And of course the court has their own recollection, so I would defer to court things. He thought that the last instance of the father being under the influence was a long time ago. He explained circumstances when mom gets upset, when dad gets upset, when the child gets upset. And I'll just defer to the court's record of that. He was asked if he ever felt intimidated by his father. He answered that not by my father, but my stepfather tries to. He also indicated that his cell phone is almost always with him. In this case, we have the boys in one room on February 4th, and the cell phone is in a different room. I believe the factors that need to be looked at in this case are the wishes of the child, although the child did not express a preference either way. He certainly didn't express a preference to not be with his father. Factors regarding the level of conflict. Clearly, there is a level of conflict, but they've been able to get along with a week on, week off for 9 years and for joint custody for 12. Which parent is more likely to allow the child to have frequent associations? It doesn't seem to be in favor of either parent there. My client was unhappy with 150 requested changes to the visitation schedule. Seems like an awful lot. That's a lot more than a family vacation or relatives coming into town. The nature of the relationship of the child with each parent was described by a good relationship. There was no adverse information regarding the ability to have a relationship with his half-sibling. There is no allegation, well, there is no evidence of parental abuse or neglect of. With that said, again, yeah, what happened on February 4th is regrettable. We have no evidence of any abduction by either parent. We have conflicting testimony regarding a history of domestic violence. And I'm not suggesting that control or the wheel of domestic violence doesn't describe things that are other than actual physical acts. But at the same time, we're looking at information that is very, very remote in time. And in fact, there have been no attempts to hurt her. There have been no reported. She sits here in court with us today. How many minutes do I have, Judge?
9 minutes, 34 seconds.
Oh my God. Getting more than I thought.
Leave it to attorneys, you'll take all the time. No, the time is yours, Mr. King, take it at your leisure, sir.
Thank you. One of the areas that I found interesting was that she's fearful of my client and has been fearful for many, many years, yet she would come over and sit right next to him at a soccer game. Now, how does that comport with her claim of fear? I believe that this is a situation where mother has been simply waiting for an opportunity to try to change custody, that she's unhappy with arrangements as they are. that's not a legal basis to modify custody. My notes reflect that I think that both parents only talk about each other in a good way. Excuse me. I think it was asked if either parent asked him to keep secrets, and he said no, neither one. Yet here we have Dr. Forge having comments in his report to the opposite. I think also stated that his father does not talk about the custody visitation schedule. I guess I didn't need 20 minutes.
Okay. Let me reset the 5 reserve, Ms. Cooper, bear with me. Your 5 minutes of reserve starts now.
I'll just say sitting down this time. Okay, a couple of things. I think it's interesting that they're worried about a trial by ambush when that's the entire litigation strategy that's been in this case. There have been, Mr. didn't file these on time. When he did file them, he filed them inappropriately. He didn't have appropriate documentation, didn't have appropriate legal citations, which then made this case more expensive and more difficult because he's jealous and believes that she has a more fluid lifestyle, so therefore she should be punished by doing this extra stuff. There is zero evidence of Ms. having wrongdoing with respect to our family wizard messages or text messages. Nothing has been presented on that. You have several exhibits on the issue. You can look closely at the language, tone, and timing of any one of those things. And, you know, I don't know Mr. King's opinion. I don't know that he's the person to tell what's reasonable or not reasonable in a co-parenting relationship, but there's a lot of things that need to be discussed. Look at it yourself. Tell us if it's a real problem. If there was, Mr. provided that information to us. Now, with respect to Dr. Court's recommendation saying that Mr. is capable, if you recall, we were initially asking for sole physical custody, which under the Roe case requires a very high standard of finding someone essentially incompetent as a parent. And he testified that that's a low bar of the capable parent. So we abandoned the sole physical custody and then asked for primary custody in recognition that that is the standard and we didn't believe that was met in this case. The recommendations that Court made weren't really altered that much. It was basically he accentuated or added to the findings that he had already made about Ms. being self-centered, not being able to recognize his responsibility for things, being quick to temper, having a hostile attitude towards other people, which is pervasive in this case and with Ms. There's been a change in circumstances here because initially the horrific violence was aimed at Ms. It calmed down for a period of time and then he became more controlling and manipulative and mean, using abusive language after his relationship with Lindsay. While Ms. thought there may be something going on with, she referred those issues to his therapist in order to be problem solving with Mr. testimony regarding that. When that became apparent that when it changed from that and issues that were being addressed as they go, it changed to self-reporting a traumatic experience where he was afraid of his dad and thought his dad was going to hurt him and asked for his mother's help. That is not someone lying in wait for 13 years to make a change to a custody schedule. That is a direct change in what the perspective is of the co-parenting relationship. She took appropriate action, she filed the motion, we addressed it all within the court. He relies heavily on testimony. I would say that testimony was not credible. He had, as I said before, he had a great change in position and mannerisms, but when he had to talk about the issues here. What we're looking for is primary custody on a stepped-up plan, consistent with Dr. Cord's recommendations. And so what we would suggest is that they stop at the Family Peace Center, go to therapy, in-office supervised at least one time per week for 2 months. One time per week, then have it in office and not supervised, but within the check-in, like Dr. Cord suggested, and that go for a period of 2 months. Then we'd suggest that he have daytime visits within the community with a check-in with the therapist afterward for another 2 months. Then the next 2 months, do an overnight, again with a check-in with a therapist. I presume that at that point they won't need as much interaction with the therapist that's helping with that reunification, and at that point we'd suggest every other weekend visit. Holidays to stay the same as they were before. We would like there to be random look-back testing to test for alcohol and marijuana because there has been a diagnosed problem. Mr. to be sober. It's important that forensic therapy recommended by Dr. Cord, that the parties follow the other recommendations made by Dr. Cord as to their behavior and how they deal with anxiety. We also here along the way have discussed attorney's fees and in your order previously, you said we could either address them now or later. Considering the time, we'll go ahead and address those in a separate motion.
Thank you. 8 seconds remaining.
Oh, look.
Okay. So council, a couple of things. Obviously, to the extent that new affirmative requests for relief are raised in a closing, it's nothing that I can do anything about, so I accept those purely for the reasons offered, that they're part of closing, but not as an affirmative request for relief in a motion. The request for attorney's fees was to be decided separate and apart, and it will be decided separate and apart. The timeline under Rule 54, if attorney's fees are believed to be an issue, you'll see the timeline outlined in the final order after the hearing. But yes, I did not expect council to argue that today without knowing which direction this case was going to go, and there was no directions from the court with regard to the Brunzell factors or the Miller versus Wilfong affidavits. So that'll be addressed separately as well. Go
Sorry,
ahead.
Your Honor. There was one thing that I forgot that you had in an interim order as well, and so I'm hoping we can address that by the separate motion. It's on the fees. You reserved the opportunity to ask for a reallocation of fees, not of Dr. Cord's testimony, but of the evaluation. Can we handle that in a separate one, or should we discuss that now?
No, well, let me back up and say this. Fees and costs frequently not litigated correctly, in my opinion, in the family court arena. The rules still apply the same. So I reserve the rights that you wouldn't have to do that during the pendency of the case. If she's gonna ask to tax costs, you'll have to file that separately, but I will address it separately. I did reserve it.
Right.
So what I will say is I'm just gonna extend the deadlines on all of that. You're not gonna have to do the fees or the costs until after the final order comes out, so I'm extending the deadline there. Taxing costs or memorandum of costs, if there's an indication in the order, and again, this is just cleanup, so no one should be taking my comments as which way the wind is blowing. That's dangerous to start opining about what a judge is thinking when we're actually not thinking, because I haven't had time to go through all the evidence. But counsel, yes, you'll have an extension of time. It'll be 14 days from the issuance of any order for costs, and it'll be at least 21 days for the attorney's fees. 21 days is under Rule 54. I think taxing of costs is 7 days, which I think is really short, especially right now with holidays coming up. So it'll be no less than 14 and 21 respectively. It might be longer once the order comes out, or it might simply be that there are no grounds. I don't know, but I won't give you less than that time if attorney's fees and costs are something that we pursue. I know that there's a request with regard to the temporary issues, so let me just address that kind of legally today. This case has been fast-tracked from it doesn't feel that way to you, Mr. that it's been fast-tracked. And to Ms. projecting, I have no idea if you feel it's been too fast or too slow. But what I can tell you is pursuant to the Nevada Supreme Court rules, which I try to adhere to as much as I can, even though they're really tough given the volume of cases, there was an emergency motion back in February. That's not even the motion that all of these things are triggered under. But under the Nevada Supreme Court rules, I'm supposed to have a final trial and decision as best I can within 6 months of the date that the notice motion is contested. The ex parte motion, that is not the triggering event, was early February of 2024. We're having trial in June. We're already fast tracking all of this. I believe that I set the trial at the time that I got the emergency motion so that I wouldn't delay it even another 60 days while you guys briefed the underlying motion. Both counsel knows this, but the parties may not. Every judge goes on a 60-day list on the 10th of every month if we haven't gotten our things out. It's not necessarily a bad list or a good list. We have thousands of cases. Right now I have 4 other big trials that are in the queue in front of you. One of them has an oral ruling and takes precedence because it's a jurisdictional matter. The other 3 are still in front of you. This case will still take precedence the way I do my cases. This case will take second-degree precedence. I have to rule on the jurisdictional issue to keep that case moving. But because I have a father who's got supervised visitation, his case gets bumped up. So other cases may go on the 60-day submit list, but you guys will actually be the second one in line rather than the 5th one in line. So I do endeavor to get something out to you quickly. The oral ruling on the other case in front of you is to be done no later than, I believe, July 12th. So I would expect that you'll have a ruling in this case before the end of July on the expedited basis. All of that tells you, does make you feel any better, Mr. You sit there today with having supervised visits. But in accordance with the law, I don't know how I can act any differently, because having found emergency basis and having that reconfirmed during trial today, I stuck with an emergency order, but those emergency orders made before I hear any testimony and evidence. So now I'll have to go back and look at the testimony and evidence and see if it warrants a change from the original order or not, and I'll do that quickly. But as far as completely changing all of the temporary orders, Mr. King, I'm not comfortable doing it today because I think I would still have to do it on an expedited basis, because I can't say to you today that I've looked at everything that has come into evidence. So I can't make an evidentiary ruling. So I decline to make any changes on an expedited basis other than I will move their case to the 2nd in the queue rather than the 5th, because I do think that it warrants that degree. Is there anything else that I can give as far as timeline? So counsel, if you don't have a ruling from me by the end of the month, I'm happy to try to do an oral ruling, but in this case, I think it's just going to be best if I draft it myself anyway. I expect you're going to have a ruling by the 29th of July. My hope is that you have it faster than that. But looking at the trials on calendar and what's coming up, you will have it by July 29th. So we will tickle it for that day, one way or the other. Council knows that if I get in a bind and can't get, I'm sure that this order will be incredibly lengthy. If it's going to be one of those orders that I just can't get all of the findings in, then you'll receive a call to council's office. And Mr. King has been through this before. I think Ms. Hardy Cooper might have had a case that had to go this route. But if time is of the essence and I can't get all of the findings done, then your attorneys will get a call that says we're going to have an oral reading, and I'm going to give you the order, what it is, and then finish up all of the findings thereafter to at least get you on your way so that you know what it is that's coming, so that you can move in that direction. And I'm happy to do that in this case. I still hope that I'll get the written order out before the 29th, but if not, council will have a call from my office. Anything else that either council needs from me today before we adjourn? Okay. Thank you both. These are highly emotional issues. Council, I appreciate the respect shown in court to the public. It's difficult for us on the family court side to have public in our courtrooms in these very intensely private matters. This is the law of the land. I appreciate everybody that was here for being very respectful of the process. So we're adjourned, and you're welcome to take your time and clean up. There is nobody in here behind you. Have a good morning.